Hello friends, I welcome you all here at TNV Academy. In this session, we are going to talk about the chapter 1 of General Data Protection Regulation. In short, we call it GDPR. The GDPR mainly focuses on controlling and processing of personal data of natural persons. The protections are available only to natural persons. In other words, we can say that artificial persons or any entity in the eye of law which is an entity but not a natural persons, then the protection under GDPR is not available to these persons. In other words, we can say that artificial persons or any entity in the eye of law which is an entity but not a natural person, then the protection under GDPR is not available to these artificial persons. The rules as enacted under GDPR protects the personal data like PAN card data, passport data, Aadhaar card data, identity card of citizenship data. There are like many documents which may be identity proofs or address proofs of a natural person. Let us understand the meaning of personal data. Personal data means any information relating to an identified or identifiable natural person. Data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. Before start of the main requirements, we wish to intimate you that the GDPR regulations are explained and divided into 11 chapters, and chapters are further divided into articles. Here, we are going to start it by chapter 1, which contains 4 articles as detailed below. Article 1, Subject Matter and Objectives. Article 2, Material Scope. Article 3, Territorial Scope. Article 4, Definitions. Now, let's understand each article separately. Article 1 is titled as Subject Matter and Objectives, and it sets out the general frameworks regarding the processing of personal data in European Unions. The Article 1 is described into 3 sections, which is known as Article 1.1, Article 1.2, and Article 1.3. These 3 are explained as follows. First Article 1.1 states that regulation lays down rules relating to the protection of natural persons with regard to the processing of personal data and rules relating to the free movement of personal data. Under this, the regulation establishes 2 main aims. First aim, protecting the natural persons with regard to processing of personal data, and second aim, free movement of such personal data within European states. Now, let's understand Article 1.2, which states that this regulation protects fundamental rights and freedoms of natural persons and in particular their right to the protection of personal data. It means the protection of natural persons in relation to the processing of personal data is a fundamental right. The regulation generally protects the fundamental rights and freedoms of individuals. However, the fundamental rights and freedoms as protected by the GDPR are not defined, and one has to refer the Charter is the primary law of the European Union. Now let's understand Article 1.3, which states that the free movement of personal data within the Union shall be neither restricted nor prohibited for reasons connected with the protection of natural persons with regard to the processing of personal data. It means the regulation protects and allows that the processing of personal data of natural persons may be essential for certain economic activities, shall be freely movable without any restrictions within the member states of the EU. The regulation facilitates the harmonization of the data protection across European unions, as well as Iceland, Liechtenstein, and Norway as part of the European Economic Area (EEA). Now, let me explain you the Article 2, which talks about the material scope. The material scope is defined into four sections of Article 2.1, Article 2.2, Article 2.3, and Article 2.4. Article 2.1 states that this regulation applies to the processing of personal data wholly or partially by automated means and to the processing other than by automated means of personal data which form part of a filing system or are intended to form part of a filing system. It refers that the GDPR applies to the processing of personal data by automated means. The term automated means is not defined in the GDPR regulation. However, as per the dictionary meaning, it should be understood that any process in which at least part of data is processed automatically using a given program without any human intervention. The data processing must be fully or partially automated. It means automated processing may be through automated means. It may be wholly or partially. Let's understand this by an example. Here, we fill the identity number manually into a digital database, and then the system processes the data for filing purposes. It is called partial automation. Here, there are several processes of operations. One part is filled manually to process the data for filing purpose, and rest part will be processed automatically. In addition, there may be manual process of data for filing purpose or intended for this purpose. The term filing purpose has been defined in Article 4.6, which we will understand later in coming video session. Next, the Article 2.2 contains a negative list wherein GDPR regulation did not apply. This is exceptions to the general rule of GDPR, and list is as follows where the protections under GDPR are available. Point 1. In the course of an activity which falls outside the scope of union law. Point 2. By the member states when carrying out activities which fall within the scope of Chapter 2 of Title V of the TEU. Point 3. By a natural person in the course of a purely personal or household activity. Point 4. By competent authorities for the purposes of prevention, investigation, detection, or prosecution of criminal offences or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. In the above conditions, the regulations are not applied. Hence, the processing of personal data of any natural persons are not protected. Next, the Article 2.3 states that for the processing of personal data by the union institutions, bodies, offices, and agencies, Regulation EC number 45/2001 applies. Regulation EC number 45/2001 and other union legal acts applicable to such processing of personal data shall be adapted to the principles and rules of this regulation in accordance with Article 98. This refers that while union institutions or bodies or agencies, while processing the personal data, the Regulation EC number 45/2001 shall be followed, along with GDPR regulation and other legal applicable laws. Further, The provisions of Regulation EC number 45/2001 and other legal laws as applicable on such procession shall be followed. Next, Article 2.4 states that this regulation shall be without prejudice to the application of Directive 2000/31/EC, in particular of the liability rules of intermediary service providers in Article 12 to 15 of that directive. This refers that the GDPR regulation shall be applied without avoiding the provisions of EC Directive 31/2000, especially the liability rules as prescribed under Article 12 to 15 of EC Directive 31/2000. In other words, we can explain it that the EC Directive 31/2000 shall also be complied with even though the GDPR regulations are applied there. Now, let's understand the territorial scope of GDPR is set out in Article 3, which provides broad definition. Point 1. This regulation applies to the processing of personal data in the context of the activities of an establishment, of a controller or a processor in the Union, regardless of whether the processing takes place in the Union or not. Point 2. This regulation applies to the processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union, where the processing activities are related to. First, the offering of goods or services, irrespective of whether a payment of the data subject is required, to such data subjects in the Union, or second, the monitoring of their behavior as far as their behavior takes place within the Union. Third, this regulation applies to the processing of personal data by a controller not established in the Union, but in a place where member state law applies by virtue of public international law. We can explain it that the GDPR permits for any business located anywhere in the world to fall under its purview if a business offers goods or services in the EU or monitors the behavior of EU citizens, irrespective of whether it has presence in Europe or not. This is very wide, and the scope covers everything which is offered in the EU or its monitors the citizens of EU, then the GDPR regulation shall apply. The territorial scope of GDPR is very wide, and it covers big ranges which is offered in EU or affecting the citizens of EU. Now, let's understand the Article 4, which defines the various terms used in the GDPR. The terms used in the regulation like personal data, processing, restriction of processing, profiling, pseudonymization, filing system, controller, processor, recipient, consent, personal data breach, genetic data, biometric data, data concerning health, main establishment, etc. are defined in this article. The intensions of terms shall be used as per the definitions given in the article. We have to understand the definitions of terms to understand the GDPR provisions. Now, let's explain you the major benefits of this training session on Article 1 to Article 4 of the GDPR. The benefits are as defined in following points. Point 1. Understanding the subject matters and its objectives and the protections given in the GDPR. Point 2. Understanding the data security and data processing. Point 3. Understanding the definition of terms used in the GDPR like personal data, processing, protection, etc. Point 4. Understanding the material scope as well as territorial scope of the GDPR. Many more benefits of this training session are as described above. The organization will grow more as their data will become consolidated and easier to use and having greater understanding of its underlying value. See you soon with an exciting new topic. Till then, goodbye.